Hello, and welcome back. I'm attorney Andrew Bethel of Bethel Law, where we dive deep into estate planning, finances, real estate, and taxes. Today, we're revisiting and modernizing an older video on a topic that generates a lot of questions in our office: joint tenancy versus tenants in common. This video will be more polished and comprehensive than the original. I'll discuss some real case examples as well, so like, subscribe, share the video with anyone who owns property or who's considered buying, and let's dive in. Before we get into the differences between joint tenancy and tenants in common, let's start with the basics. Concurrent ownership simply means that two or more people hold title to the property simultaneously. The two most common forms of concurrent ownership are joint tenancy and tenants in common, with an honorable mention for community property with a right of survivorship. All forms have significant implications for what happens to your interest in the property after you pass away, which is probably what you're all here for, so let's begin with joint tenancy. Joint tenancy involves two or more people holding property together with the right of survivorship. This means that when one owner passes away, their interest in the property automatically transfers to the surviving owner or other owners. Here are some key points to remember. First, right of survivorship. Upon the death of one joint tenant, their interest automatically goes to the surviving joint tenants. For example, if a husband and wife own property as joint tenants and the husband passes away, his interest in the property automatically transfers to his wife, making her the sole owner. And number two, for unities. Joint tenancy requires the unity of possession, interest, title, and time. Number one, possession. All joint tenants have an equal right to possess the entirety of the property. This means that both can occupy the property and one cannot exclude the other, at least without some type of agreement like a rental contract. Second is interest. Each joint tenant must have an equal share in the property. You cannot have one joint tenant with 25% and the other with 75%. It must be equal. If there are two people, then 50-50. If there's three, then 1/3 each, and so on. Third, title. Joint tenants must acquire their interests through the same document. And four, time. Joint tenants must acquire their interests at the same time. Title and time go together in that the joint tenants are going to have acquired their interest in the same deed. For example, Frodo Baggins hereby grants the property Bag End to Samwise and Rosie Gamgee, husband and wife as joint tenants. If Frodo had executed a deed to Samwise before then executing a deed to Rosie, then there wouldn't be a unity of title and time, since Samwise and Rosie each received their portion of Bag End at different times on different deeds. Thus, Samwise and Rosie couldn't hold the property as joint tenant in that case, even though they may have equal interests in the property. Samwise and Rosie would then have to execute a deed transferring the property from themselves back to themselves as joint tenants to change how they hold title. Next, let's briefly discuss community property with the right of survivorship. This is a way for spouses to hold property jointly in a community property state such as California. This way of holding title functions the same way as joint tenancy. It's just making it explicit that the real property in question is community property of the marriage. We'll do a video diving into the details of the differences between community, quasi-community, and separate property, but for today, just know that community property is generally divided 50-50 in a divorce, while separate property is retained entirely by the owning party in a divorce, and not every state makes these distinctions. In fact, only 9 states do so: Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, and Wisconsin. You're now probably wondering, what's the point of community property with the right of survivorship when it functions just like joint tenancy? Well, the answer, of course, comes back to taxes, particularly capital gains taxes and a stepped up tax basis. I won't go on a tangent to our current tangent again, so just know that when a property is community property of a marriage, then when one spouse dies, we can have the entirety of the tax basis in the property step up to the date of death value. This means that if or when the surviving spouse sells the property, the amount subject to capital gains tax is going to be the difference between the sales value and the value of the property at the deceased spouse's date of death, rather than the initial purchase price by the couple. Thus, a lesser amount of money is subject to capital gains tax, meaning an overall smaller tax bill. We only get this tax break if the property is community property, hence the specific way of holding title. However, typically, property you hold jointly with the spouse would be considered community property anyway, but in this case, we're just making that more explicit. To summarize, community property with the right of survivorship functions like joint tenancy, but makes it easier to qualify for tax breaks if a spouse sells the property after the death of the other. All right, now let's discuss tenants in common. Tenants in common is another form of concurrent ownership that carries fewer restrictions and a significant difference from joint tenancy: no right of survivorship. Some key points include the following. Number 1, undivided interest. Tenants in common each own a specified share of the property, which can be unequal. For instance, one owner might hold 60% interest while the other holds 40%. Number 2, no right of survivorship. When a tenant in common dies, their interest does not automatically transfer to the other owners. Instead, it becomes a part of their estate and is subject to probate if they didn't either execute a transfer on death deed or put their portion of the property into a trust. And 3, flexibility in ownership. Unlike joint tenancy, tenants in common do not require the unities of interest, title, or time. Owners can acquire their interests at different times and from different sources. If you'll recall our example where Frodo transferred one half of Bag End to Samwise on one deed and the other one half to Rosie on the second deed, that transfer did not have a unity of title or time, thus Samwise and Rosie would own the property as tenants in common in that case. Now, the right of survivorship is the biggest distinction between joint tenancy and tenants in common. In joint tenancy, the deceased owner's interest automatically transfers to the surviving owner or owners. This can simplify the transfer of property after death, avoiding probate. However, in tenants in common, the deceased owner's interest goes into their estate, potentially necessitating probate to clear the title. Understanding the differences between joint tenancy and tenants in common is crucial for effective estate planning. Here's some things you need to consider. First, avoiding probate. Joint tenancy can help to avoid probate, but it's not suitable for all situations, especially if you want to control how your property is distributed after your death. Additionally, if there's simultaneous death of all the title holders, then we're in probate court for both owners' estates. And if there's an incapacity issue with one of the joint tenants, then unless they had a robust power of attorney, we're going to be stuck with a property we can't move because one of the title holders is incapacitated. Second, using trusts. For more control, to avoid probate, and to avoid anything freezing in place due to incapacity, consider placing your property in a living trust. This allows for a smooth transfer of your property according to your wishes without the need for probate. And 3, review your deeds. Ensure your property deeds clearly state your chosen form of ownership. If the deed is silent, well, let's talk about that next. If a property deed does not specify whether the owners are joint tenants or tenants in common, then the California Civil Code presumes the property is held as tenants in common. Additionally, the deed does not specify the shares each owner has. It will be presumed to be equal shares. However, it's not like it costs extra when drafting a deed to simply specify either joint tenancy or tenants in common, so don't leave something like this up to chance. Be specific and crystal clear when transferring property to someone else, or make sure the drafting party is explicit if you are receiving property. In summary, the key difference between joint tenancy and tenants in common is that right of survivorship. Joint tenancy includes this feature, making it easier to transfer property outside of probate, while tenants in common does not, potentially requiring probate. And community property with a right of survivorship is, in essence, joint tenancy, but for a married couple. So let me ask you, do you hold property as joint tenants or tenants in common? Check your deeds and consider your estate planning needs. Remember, placing property in a trust can provide greater control and avoid probate altogether. Thank you for watching. Be sure to like, subscribe, and share the video with your loved ones to make sure that their estates are in order. I'm attorney Andrew Bethel, and I'll see you at our next meeting.